This video is on common law assault and battery. It's an interactive video resource, so that means you will need to pause on the various points, especially where there are questions, because if you let the video run, it will run much too fast. But it does enable you to pause wherever there are questions or wherever you would like to reflect further. Towards the end, there'll be a number of cases, and there'll be time for you to again pause and then look up the facts of those cases. So let's begin. The objective is for you to be able to answer a problem-style scenario on non-fatal offences involving common law assault and battery, which is part of Section 39 of the Criminal Justice Act 1988. And the scenario that we're looking at today is this one. So you may need to pause it on each slide and follow me as I read it through. Carl was waiting patiently in a queue at a fast food outlet. Dan, who was behind him, was in a hurry and was getting angry about the slow service. When the queue moved forward, Carl did not immediately move forward as well. This annoyed Dan, who pushed Carl in the back, causing him to stumble and fall onto Enid, an old, frail lady who was knocked over but was unhurt. Dan, who had never been in trouble with the police, was horrified at what had happened and started to help Enid immediately, who was later diagnosed with a broken hip. You may want to pause here and just look through the facts, and what I ask my students to do is to highlight keywords, any information, and to make sure that they think about why they've actually highlighted certain words that will then help them answer the question. So the question is, and there will be two. The first one, discuss the criminal liability of Dan for pushing Carl. And that will be 7 marks. And the second question, discuss the criminal liability for the injuries suffered by Enid. And that is also 7 marks. Now let's consider both common law assault and common law battery, beginning with assault, part of Section 39 of the Criminal Justice Act 1988. Now the actus reus of an assault is, if you've already done some research, then you might want to pause it here and remind yourselves before the answer comes up on the screen. So remember, this is the doing part. The actus reus is the doing part of a crime. And the answer is causing the victim to fear immediate and unlawful personal violence. So if that's the AR, you know that there is also an accompanying MR, so the blameworthy mind. So the blameworthy mind for a Section 39 assault offence, a common law assault offence, would be, again, pause the video here, or else let it run and the answer will appear next. And it's the intention to cause another to fear immediate unlawful personal violence or recklessness as to whether such fear is caused. Okay, so that's intention or recklessness. And this is also known as a basic intent crime because the mens rea is quite wide. It has both, you could prove either that this person intended this crime or they were careless, didn't really care and took the risk. So they were reckless. Now the types of assault and examples of them could include the following: raising a fist as though to strike a person, sending a threatening text, pointing a loaded gun at someone, throwing a brick that just misses a person. This is quite a famous case. Smith versus Woking Police Station. You could pause here and you could look at the case if you haven't come across it before. If you've come across it before but can't quite remember, this picture might be a clue. Now the facts of the case were as follows. The defendant entered a private garden at about 11 p.m. He peered through a bedroom window at the victim, a female who was terrified. There are two legal principles for this case. Do you know them? They will come up next on the screen. Legal principle 1. Where violence could be a possibility in the immediate future, then the actus reus for an assault can exist. Because he argued that he couldn't actually have got to her because he was on the other side of the window. Now, a woman who notices a man peering through her window at that time of night is going to be afraid. I don't think she's going to be able to rationalise and think, oh, all the doors and windows are locked. When you're in a state of fear, you don't tend to think rationally. Legal principle 2, the word immediate in this case was interpreted quite generously by the courts. So immediate was interpreted to mean imminent. Now pause this video here to look up what the word imminent means. How is the word imminent different from the word immediate? If you pause to look up the words, you will have found that imminent means something that is about to happen or something that is fast approaching, whereas immediate means something that's happening now or right here on the spot. Additional information on assault, which you may have found when you were researching, is that assault requires acts or words, and in the Constanza case, even kind of letters were enough. Words can negate an assault. That means they can take away an assault. So you could cause an assault through words, and you could also take one away. Gestures can also be enough, so can silent telephone calls, as per the case of Ireland. Now, if there are any of those cases that you're not familiar with, please pause and look those cases up. Let's now move on to battery. Battery comes under Section 9 of the Criminal Justice Act 1988, as did assault, common law assault, which we just looked at. And the AR of battery is, you may want to pause here, the application of unlawful force, and the mens rea, either an intention to apply unlawful force or recklessness as to whether unlawful force is applied. Now, what is similar in this MR to the MR for assault? Yep, both intention and recklessness, so it's a wide mens rea, and this is also then a basic intent crime. Let's now look at some examples of battery, or you may want to pause here and note down some of your own before taking a look at the ones I've got. So, examples are an indirect force via a booby trap. So, it's if I dug a hole inside my classroom before you came in and you opened the door and you all fell in, that would be a trap that I would have then covered over with the carpet, but you would also have experienced a level of force as you fell into the hole. Hitting someone with a stone, slapping, kicking, punching. What kind of injuries could indicate a battery? Bruises, grazes, scratches, swellings, reddening of the skin, abrasions. Here are some relevant cases. Now see if you can recall the facts if you've already done some research, and if you haven't, then pause here and look up the cases of Martin, Thomas, DPP versus K, the Haystead case, and the Fagan case. And once you've done that, a series of pictures will come up on the screen. See if you can identify the cases using the pictures that come up. So here is a hand dryer. It's one of those ones where you can turn that nozzle up and down. Which case does this remind you of? A girl in a skirt? Can you recall which case that might be? A man with, well, it's the closest picture I could find, with a man using an iron rod across a door. A woman with a baby. And then the last picture, a police car and another car that's on a pavement. Does that ring any bells? Further detail on battery. Battery doesn't have to be direct. It can be indirect, as in the case of Martin. It requires the least touching of another person, R versus Thomas. And now you're ready to look at the scenario again that we started this video presentation with. Pause the video here if you want to and just remind yourselves of the scenario. But I'm going to move on to the structure of how to answer a problem type scenario. And this is a common one that's used. There is one other kind of structure, and that's called ILAC, but I'm going to use IDEA. IDEA would be identify the law, define the law, explain the law, and apply the law to the facts. And we're going to do this next. So I'm going to take the first question, and that question was, discuss the criminal liability of Dan for pushing car. Now take a look. To identify, I need to identify exactly which non-fatal offence it is, and this is how I would start it off. I would actually pull out information from the scenario, and very soon after I would identify which one it was. So Dan pushes Carl in the back, causing Carl to fall into Enid, a frail old lady. Whilst Carl is uninjured, the lady suffers a broken hip. This scenario deals with the area of non-fatal offences. In particular, I will be considering battery. So what I've done is brought in the relevant facts and I've identified what it is. So it's battery. Now I'm going to define battery. Now to define it, I need to say where it comes from. So it comes from Section 39 of the Criminal Justice Act 1988. It's important that I say that. And then I need to provide both the actus reus and the mens rea, which you saw earlier on in this interactive video presentation. And what you'll find here is that the definition combines both the actus reus and the mens rea. So once you've done that, you move on to explain. Now I would say think about 5 points of law as a minimum when you are explaining. Okay, so as I'm explaining, I'm going to do that using the AR and MR. So the AR consists of the application of unlawful force on another. The term force is misleading. All that is required for a battery is that the defendant touches the victim without their permission or their consent. The mens rea, it must be shown that the defendant either intends to use unlawful force or that he knows there is a risk that what he is doing might result in the use of unlawful force. Knowing of the risk makes this subjective recklessness. I'm continuing with more facts. Battery is the actual application of unlawful force. For example, when A raises his fist, threatening to punch B in the face, that's an assault. The moment the punch lands on B's face, it's a battery. Battery is a standalone offence. It doesn't require for there to have been an assault. Battery can be direct or indirect. Bring in key cases. Martin, DPP versus K, R versus Haystead. It can be the slightest touch, as in touching someone's clothing where there is no permission to do so, as in Thomas, and it does not need to result in injury. There may be a battery where the defendant accidentally applies force to the victim and then wrongfully refuses to withdraw it, and that was in the Fagan case. I'm moving on to now application. Application is where you apply the law you've explained. So you've explained the law, now you're applying it to the scenario. Okay, so by pushing Carl in the back, Dan has clearly inflicted unlawful personal violence on Carl. And this satisfies the AR requirement. And I can see that I've got a typo there. I've got Carl written twice. So, by pushing Carl in the back, Carl has. That was a mistake. I do apologise. So the AR requirement is satisfied, and Dan clearly wanted Carl to move, and so Dan had a direct intention to apply unlawful force. So this satisfies the MR as well. He didn't injure Carl, but injury isn't required for a battery. All the relevant elements of both the actus reus and the mens rea exist. Now, immediately following your application, it's best then to conclude. and I've done this next, and this is short and sweet. Dan could be charged with battery under Section 39 of the Criminal Justice Act 1988, because I've said everything I needed to. I identified, defined, I explained the law, and I applied it. Now, in order to answer the next bit, which is discuss the criminal liability of Dan for the injury suffered by Enid, you will need to now research both Section 47 of the Offences Against the Persons Act, as well as Section 20. Okay, so that's Section 47 and Section 20. Use idea and have a go. So remember, identify exactly which offences are applicable, define them with the AR and MR, give at least as a minimum 5 points of law for your explanation, apply and then conclude. I hope this video was useful. I will be posting more in the future that are related to working with applying the law to problem scenarios. Thank you for listening and watching. Goodbye.